Jurisdiction, in law, the authority of a court to hear and determine cases. This authority is constitutionally based. Examples of judicial jurisdiction are, appellate jurisdiction, in which a superior court has power to correct legal errors made in a lower court; concurrent jurisdiction, in which a suit might be brought to any of two or more courts; and federal jurisdiction, as opposed, for example, to state jurisdiction. A court may also have authority to operate within a certain territory. Summary jurisdiction, in which a magistrate or judge has power to conduct proceedings resulting in a conviction without jury trial, is limited in the U.S. to petty offenses. Jurisdiction is the legal term for the legal authority held by a legal entity to enact justice. Jurisdiction is rarely claimed to be complete, rather it is limited, for example, by geography, subject matter, or other factor. It is only within the scope, inside the limits, of such jurisdiction that, for example, the parties to a dispute have standing to bring the matter, a legal question, before a judge, who has power, or jurisdiction, to decide it authoritatively. A jurisdiction can also be understood as a category name for any separate polity legally constituted as such for any government with legislative and other legal power over a particular territory, whether that area is a nation-state or some smaller region. Thus, Australia, Arizona, North Yorkshire and New York City are each a jurisdiction. In federations like the United States, jurisdiction in this polity sense applies at multiple levels, example local, state, and national/federal. Jurisdiction draws its substance from international law, conflict of laws, constitutional law, and is often thought to include the powers of the executive and legislative branches of government to pursue policies and allocate resources so as to best serve the needs of society. International dimension. Generally, international laws and treaties provide agreements which nations agree to be bound to. Such agreements are not always established or maintained. Extraterritorial jurisdiction is exercised through three principles outlined in the UN Charter. These are equality of states, territorial sovereignty, and non-intervention. This raises questions of when can many states prescribe or enforce jurisdiction. The Lotus case establishes two key rules to the prescription and enforcement of jurisdiction. The case outlines that jurisdiction is territorial and that a state may not exercise its jurisdiction in the territory of another state unless there is a rule that permits this. On that same note, states enjoy a wide measure of discretion to prescribe jurisdiction over persons, property, and acts within their own territory unless there was a rule that prohibits this. Political issue. Supranational organizations provide mechanisms whereby disputes between nations may be resolved through arbitration or mediation. When a country is recognized as de jure, it is an acknowledgement by the other de jure nations that the country has sovereignty and the right to exist. However, it is often at the discretion of each nation whether to cooperate or participate. If a nation does agree to participate in activities of the supranational bodies and accept decisions, the nation is giving up its sovereign authority and thereby allocating power to these bodies. Insofar as these bodies or nominated individuals may resolve disputes through judicial or quasi-judicial means, or promote treaty obligations in the nature of laws, the power ceded to these bodies cumulatively represents its own jurisdiction. But no matter how powerful each body may appear to be, the extent to which any of their judgments may be enforced, or proposed treaties and conventions may become, or remain, effective within the territorial boundaries of each nation is a political matter under the sovereign control of each nation. International and municipal. The fact that international organizations, courts and tribunals have been created raises the difficult question of how to coordinate their activities with those of national courts. If the two sets of bodies do not have concurrent jurisdiction but, as in the case of the International Criminal Court, ICC, the relationship is expressly based on the principle of complementarity, i.e., the International Court is subsidiary or complementary to national courts, the difficulty is avoided. But if the jurisdiction claimed is concurrent or, as in the case of International Criminal Tribunal for the former Yugoslavia, ICTY, the International Tribunal is to prevail over national courts, the problems are more difficult to resolve politically. The idea of universal jurisdiction is fundamental to the operation of global organizations such as the United Nations and the International Court of Justice, ICJ, which jointly assert the benefit of maintaining legal entities with jurisdiction over a wide range of matters of significance to nations. The ICJ should not be confused with the ICC, and this version of universal jurisdiction is not the same as that enacted in the War Crimes Law, Belgium, which is an assertion of extraterritorial jurisdiction that will fail to gain implementation in any other state under the standard provisions of public policy. Under Article 34 Statute of the ICJ, only nations may be parties in cases before the court, and, under Article 36, the jurisdiction comprises all cases which the parties refer to it and all matters specially provided for in the Charter of the United Nations or in treaties and conventions in force. But, to invoke the jurisdiction in any given case, all the parties have to accept the prospective judgment as binding. This reduces the risk of wasting the court's time. Despite the safeguards built into the constitutions of most of these organizations, courts and tribunals, the concept of universal jurisdiction is controversial among those nations which prefer unilateral to multilateral solutions through the use of executive or military authority, sometimes described as realpolitik-based diplomacy. Within other international contexts, there are intergovernmental organizations such as the World Trade Organization, WTO, that have socially and economically significant dispute resolution functions, but, again, even though their jurisdiction may be invoked to hear the cases, the power to enforce their decisions is at the will of the nations affected, save that the WTO is permitted to allow retaliatory action by successful nations against those nations found to be in breach of international trade law. At a regional level, groups of nations can create political and legal bodies with sometimes complicated patchworks of overlapping provisions detailing the jurisdictional relationships between the member states and providing for some degree of harmonization between their national legislative and judicial functions. For example, the European Union and African Union both have the potential to become federated nations, although the political barriers to such unification in the face of entrenched nationalism will be very difficult to overcome. Each such group may form transnational institutions with declared legislative or judicial powers. For example, in Europe, the European Court of Justice has been given jurisdiction as the ultimate appellate court to the member states on issues of European law. This jurisdiction is entrenched, and its authority could only be denied by a member nation if that member nation asserts its sovereignty and withdraws from the Union. Law. The standard treaties and conventions leave the issue of implementation to each nation, i.e., there is no general rule in international law that treaties have direct effect in municipal law, but some nations, by virtue of their membership of supranational bodies, allow the direct incorporation of rights or enact legislation to honor their international commitments. Hence, citizens in those nations can invoke the jurisdiction of local courts to enforce rights granted under international law wherever there is incorporation. If there is no direct effect or legislation, there are two theories to justify the courts incorporating international into municipal law. Monism. This theory characterizes international and municipal law as a single legal system with municipal law subordinate to international law. Hence, in the Netherlands, all treaties and the orders of international organizations are effective without any action being required to convert international into municipal law. This has an interesting consequence because treaties that limit or extend the powers of the Dutch government are automatically considered a part of their constitutional law. For example, the European Convention for the Protection of Human Rights and Fundamental Freedoms and the International Covenant on Civil and Political Rights. In nations adopting this theory, the local courts automatically accept jurisdiction to adjudicate on lawsuits relying on international law principles. Dualism. This theory regards international and municipal law as separate systems so that the municipal courts can only apply international law either when it has been incorporated into municipal law or when the courts incorporate international law on their own motion. In the United Kingdom, for example, a treaty is not effective until it has been incorporated, at which time it becomes enforceable in the courts by any private citizen, where appropriate, even against the UK government. Otherwise the courts have a discretion to apply international law where it does not conflict with statute or the common law. The constitutional principle of parliamentary supremacy permits the legislature to enact any law inconsistent with any international treaty obligations even though the government is a signatory to those treaties. In the United States, the Supremacy Clause of the United States Constitution makes all treaties that have been ratified under the authority of the United States and customary international law to be a part of the supreme law of the land, along with the Constitution itself and acts of Congress passed pursuant to it, U.S. Constant Art. 6 CL2, as such, the law of the land is binding on the federal government as well as on state and local governments. According to the Supreme Court of the United States, the treaty power authorizes Congress to legislate under the necessary and proper clause in areas beyond those specifically conferred on Congress, Missouri v. Holland, 252 U.S. 416, 1920. International. This concerns the relationships both between courts in different jurisdictions, and between courts within the same jurisdiction. The usual legal doctrine under which questions of jurisdiction are decided is termed forum nonconveniens. To deal with the issue of forum shopping, nations are urged to adopt more positive rules on conflict of laws. The Hague Conference and other international bodies have made recommendations on jurisdictional matters, but litigants with the encouragement of lawyers on a contingent fee continue to shop for forums. Jurisdictional principles. Under international law there are different principles that are recognized to establish a state's ability to exercise criminal jurisdiction when it comes to a person. There is no hierarchy when it comes to any of the principles. States must therefore work together to solve issues of who may exercise their jurisdiction when it comes to issues of multiple principles being allowed. The principles are territorial principle, nationality principle, passive personality principle, protective principle, universality principle. Territorial principle, this principle states that the state where the crime has been committed may exercise jurisdiction. This is one of the most straightforward and least controversial of the principles. This is also the only principle that is territorial in nature, all other forms are extraterritorial. Nationality principle, also known as the active personality principle. This principle is based around a person's nationality and allows states to exercise jurisdiction when it comes to their nationality, both within and outside the state's territory. Seeing as the territoriality principle already gives the state the right to exercise jurisdiction, this principle is primarily used as a justification for prosecuting crimes committed abroad by a state's nationals. There is a growing trend to allow states to also apply this principle to permanent residents abroad as well. For example, Denmark Criminal Code, 2005, SEC 7, Finland Criminal Code, 2015, SEC 6, Iceland Criminal Code, 2014, Art 5, Latvia Criminal Code, 2013, SEC 4, Netherlands Criminal Code, 2019, Art 7, Norway Criminal Code, 2005, SEC 12, Swedish Criminal Code, 1999, SEC 2, Lithuania Criminal Code, 2015, Art 5. Passive personality principle, this principle is similar to the nationality principle, except you are exercising jurisdiction against a foreign national that has committed a criminal act against its own national. The idea is that a state has a duty to protect its nationals and therefore if someone harms their nationals that state has the right to prosecute the accused. Protective principle, this principle allows states to exercise jurisdiction when it comes to foreign nationals for acts committed outside their territory that have or are intended to have a prejudicial impact upon the state. It is especially used when it comes to matters of national security. Universality principle, this is the broadest of all the principles. The basis is that a state has the right, sometimes even the obligation, to exercise jurisdiction when it comes to the most serious violations of international criminal law, for example genocide, crimes against humanity, extrajudicial executions, war crimes, torture, and forced disappearances. This principle also goes further than the other principles, as there is attached to it the obligation to either prosecute the accused or extradite them to a state that will, known as aut dedere aut judicare. Supranational. At a supranational level, countries have adopted a range of treaty and convention obligations to relate the right of individual litigants to invoke the jurisdiction of national courts and to enforce the judgments obtained. For example, the member nations of the EEC signed the Brussels Convention in 1968 and, subject to amendments as new nations joined, it represents the default law for all 27 member states of what is now termed the European Union on the relationships between the courts in the different countries. In addition, the Lugano Convention, 1988, binds the European Union and the European Free Trade Association. In effect from March 1, 2002, all the European Union member states except Denmark accepted Council Regulation, EC, 44/2001, which makes major changes to the Brussels Convention and is directly effective in the member nations. Council Regulation, EC, 44/2001 now also applies as between the rest of the EU member states and Denmark due to an agreement reached between the European Community and Denmark. In some legal areas, at least, the reciprocal enforcement of foreign judgments is now more straightforward. At a national level, the traditional rules still determine jurisdiction over persons who are not domiciled or habitually resident in the European Union or the Lugano area. National. Many nations are subdivided into states or provinces, i.e. a subnational state. In a federation as can be found in Australia, Brazil, India, Mexico, and the United States, such subunits will exercise jurisdiction through the court systems as defined by the executives and legislatures. When the jurisdictions of government entities overlap one another, for example between a state and the federation to which it belongs, their jurisdiction is a shared or concurrent jurisdiction. Otherwise, one government entity will have exclusive jurisdiction over the shared area. When jurisdiction is concurrent, one government entity may have supreme jurisdiction over the other entity if their laws conflict. If the executive or legislative powers within the jurisdiction are not restricted, or have only limited restrictions, these government branches have plenary power such as a national policing power. Otherwise, an enabling act grants only limited or enumerated powers. Child custody cases in the U.S. are a prime example of jurisdictional dilemmas caused by different states under a federal alignment. When parents and children are in different states, there is the possibility of different state court orders overruling each other. The U.S. solved this problem by adopting the Uniform Child Custody Jurisdiction and Enforcement Act. The Act established criteria for determining which state has primary jurisdiction, which allows courts to defer the hearing of a case if an appropriate administrative agency determines so. A layered or hierarchical understanding of levels of curial jurisdiction is useful to determine which questions a court may seek to answer in examining a matter based on the mechanism by which the matter came before it. Original jurisdiction permits courts to answer all questions of law and fact. This is jurisdiction possessed by a court because the matter is new, brought before a court for the first time originally. For practical reasons, courts hearing appeals from administrative bodies will also exercise original jurisdiction. This does not subvert the notion of jurisdiction, rather it points to the separateness of jurisdictions of the judicial decision maker versus, say, the executive ministerial decision maker. Appellate jurisdiction is corrective in nature. There, courts examine how lower courts and earlier decision-makers answered questions of law, whether an error was made in that process, as well as whether and how that error ought to be rectified. Their job is to correct errors made in answering the said questions, essentially, to correct errors of law. Cross-vesting scheme. The jurisdiction of Supreme Courts of states and territories may be vested in each other in special circumstances, and federal jurisdiction may likewise be vested in them. Technicalities aside, the scheme compels courts to transfer matters to another court if, in the interests of justice, the second court is a more appropriate place to litigate. In assessing the interests of justice in any particular matter, the court will have regard to the interests of the parties. The mere existence of criteria to transfer matters over to different courts nonetheless means that parties have an interest in commencing proceedings in the most convenient jurisdiction to them. The advantage conferred onto first movers is not exclusive to the Australian federal court system. Parties involved in international disputes will already be familiar with that concept. However, the threshold for intra-Australia transfer is notably lower than that pertaining to international transfer. Territorial meaning. The word jurisdiction is also used, especially in informal writing, to refer to a state or political subdivision generally, or to its government, rather than to its legal authority. This is especially useful for describing a variety of governments at a variety of levels where one cannot simply, for example, refer to states, because one of those in the set is a national government. When one has a multi-level set of governments to describe, jurisdictions is a useful plural, group, descriptor. Franchise jurisdiction. In the history of English common law, a jurisdiction could be held as a form of property, or more precisely an incorporeal heirdement, called a franchise. Traditional franchise jurisdictions of various powers were held by municipal corporations, religious houses, guilds, early universities, the Welsh marches, and counties palatine. Types of franchise courts included courts baron, courts leet, merchant courts, and the stanary courts that dealt with disputes involving the tin miners of Cornwall. The original royal charters of the American colonies included broad grants of franchise jurisdiction along with other governmental powers to corporations or individuals, as did the charters for many other colonial companies such as the British East India Company and British South Africa Company. Analogous jurisdiction existed in medieval times on the European continent. Over the course of the 19th and 20th centuries, franchise jurisdictions were largely eliminated. Several formerly important franchise courts were not officially abolished until Courts Act of 1971. Thank you for watching this video.